Hello, my name is Ashley Strauss-Martin, and I'm General Counsel for the Realtors Association of New Mexico. I'm here today to talk about the revised Residential Purchase Agreement, RANM Form 2104. The revised purchase agreement will be released through Instanet, RANM's membership forms provider, on February 2nd. It's also being provided to dotloop and to zip forms, but we don't have a release date from them at this point. Before we get started, let me provide some background. In 2014, the Forms Committee, which is made up of about 21 volunteer brokers from all over the state with varying levels of expertise, came together with myself and were given the task to conduct a comprehensive review and revision of the Residential Purchase Agreement. This is a task that hasn't been undertaken since I've been with RANM, which has been about 8 years now. So the form was reviewed for both content and format. As to content, the goal was to make the form more clearer and understandable and to eliminate redundant language. As to format, the goal was to have the form more logically flow with the transaction and to visually make it easier for the parties to read and assimilate the information. A tremendous amount of time and effort went into the revisions we will discuss. One of the biggest complaints I hear about the RANM Residential Purchase Agreement is that it's too long, and I'm afraid that these revisions did not result in a shorter form. It's actually slightly longer now. But keep in mind, the goal was not so much to make it a shorter form, but rather to make it a better form. One of the reasons for the additional length is simply formatting. In several places, multiple items or concepts that were previously in paragraph format have been broken into bullet points or subparagraphs. The former format clearly takes up less room, but visually it's more difficult to read and comprehend when the thoughts are all strung together in one paragraph, and easier to do so when they're broken out individually. As to content, some areas were revised. Sometimes this resulted in a shorter paragraph, sometimes this resulted in a longer paragraph. Again, the Forms Committee was not willing to sacrifice content for the sake of shortening the form. Please remember, the RANM Residential Purchase Agreement must serve many different needs for many different people. It must work for a seller finance sale of a manufactured home with a septic and well, as well as a single-family residence that is located in both a public improvement district and a homeowners association. The form must work for the diligent broker who consistently keeps abreast of all the new changes in the law and regulations, as well as the less than diligent broker who takes the bare minimum in regards to education. And let it not be lost that this is a contract to which the brokers are not a party, and that we, as a profession, as a professional association, must attempt to serve the best interest of the parties to this contract, the buyers and the sellers. Accomplishing all this in one form is no easy feat. I will end this introduction by quoting a 2013 case from the Supreme Court of Vermont, Knutson versus Dion. In that case, the buyer alleged that a model purchase sale contract form created through the state association had caused her damage and violated the state's consumer protection laws. The buyer's real estate broker had used the templates to create the purchase contract, just like you use ours. The court ruled that the association had no direct participation in the transaction and therefore could not be liable under the act. However, the court went on to state, and I quote, that if the buyer wanted to claim harm for any of the terms in the purchase contract, she could make those allegations against the real estate professional who recommended the purchase contract to her. Keep in mind, RANM works diligently to make the RANM forms the best that they can be, with the goal that no RANM member who uses the RANM forms will be subject to such a claim. Now let's go to the substance of these revisions. I will refer to RANM Form 2104 that was used prior to February 2nd, 2015 as the previous RANM Form 2104 or the previous purchase agreement or contract. However, I recognize that some of you may be viewing this video before the revised purchase agreement has been released. And in that event, when I refer to the previous RANM Residential Purchase Agreement, I will be referring to the purchase agreement with which you are currently working. Let's start with page 1 of broker duties. The list of broker relationships available in New Mexico and reference to RANM Form 1401 were deleted from the introductory paragraph. As the list was already addressed on page 2 of broker duties, the placement of the list on both pages was redundant. We moved reference to RANM Form 1401 to the top of page 2, with the list of brokerage relationships. We'll discuss that in a moment. With the exception of the last line, the remainder of the language is taken directly from the Real Estate Commission regulations and was not changed. The last line that states buyer and seller should acknowledge receipt of this information by initialing below was added. Real Estate Commission regulations require that brokers obtain written acknowledgement from their prospective customer or client showing delivery of broker duties. And while the buyer and seller will sign on page 2 of broker duties, it's important that the broker has a record that they received page 1. As a side note, there's an ongoing debate as to whom broker duties are owed. It's clear that a broker owes broker duties to his own customer or own client, but what if two different associate brokers represent a buyer and a seller? Does the buyer's broker owe broker duties to the seller? Does the listing broker owe broker duties to the buyer? In my opinion, it depends. If the two associate brokers work for the same qualifying broker, then arguably so, since associate brokers are agents of the qualifying brokers. This may be equally true if the associate brokers work for two different qualifying brokers, but both qualifying brokers work for the same brokerage. However, arguably, the buyer's broker does not owe broker duties to the seller, and the listing broker does not owe broker duties to the buyer if the two associate brokers work for different qualifying brokers from different brokerages. However, this is not clear from the law or the regulations. It is my understanding that the Real Estate Commission Rules Task Force is working on clarifying this issue. In the meantime, all brokers are advised to disclose broker duties to all buyers and sellers involved in the transaction. Page 2 of broker duties. At the top of page 2, after the list of various brokerage relationships available in New Mexico, RANM Form 1401 is referenced. It was previously referenced at the top of page 1 of broker duties. Form 1401 contains the New Mexico Real Estate Commission definitions of each of the brokerage relationship options available in New Mexico. The law requires brokers to disclose broker relationships available in New Mexico, but the broker duty section of Form 2104 does not explain those relationships. Brokers cannot expect that customers or clients will intuitively understand the difference between the brokerage relationships, and Form 2104 provides a resource for further information on brokerage relationships. As a side note, I'm working on a brokerage relationship information sheet which will further explain the various brokerage relationships. It will be released in 2015 and will be referenced in the purchase agreement as soon as it's available. Also in the first paragraph of page 2 of broker duties, the sentence referring to unwritten agreements was removed. It was unnecessary to state that brokers may disclose unwritten agreements with buyers or sellers. That goes without saying. Nothing else changed on page 2 of broker duties. Moving on to the purchase agreement. The offer date is still at the top of the page. Nothing significant changed in paragraph 1, but I will note that the settlement signing date that is referenced in paragraph 1 will auto-populate to paragraph 8A below. The fourth blank line in paragraph 2, where the parties were to enter the dollar amount that buyers would deliver, was deleted. We now only have 3 lines in paragraph 2. Paragraph 3, the earnest money paragraph, had 3 significant changes. First, instead of saying that earnest money must be delivered upon mutual acceptance of the agreement, it now states that earnest money must be delivered no later than so many days from date of acceptance, and the parties must fill in the number of days from date of acceptance. Also in that paragraph, a sentence was added explaining that if the earnest money is initially being deposited into the brokerage account and then subsequently being transferred to an escrow or title company, then the brokerage needs to have a separate written agreement with the parties to transfer that earnest money to the escrow or title company. Lastly, it states that failure to timely deliver earnest money shall be considered a default of the agreement. Let me remind everyone that earnest money is not required for contract formation. The requirement that a buyer deliver earnest money is but another term of the contract. This newly added language ties into paragraph 32 that now states, and I quote, "Any default under this agreement shall be treated as a material default, regardless of whether the party's action or inaction is specifically classified as a default herein." This is relevant for the following reason. Not all defaults or breaches of a contract are considered material breaches. A material breach of the contract will relieve the non-breaching party from further performance under the contract, but a non-material breach will not. Some breaches are of such magnitude that they are clearly material breaches. However, other breaches may arguably not be material breaches. In other words, even if a party fails to do what he is supposed to do under the contract, the other party is still obligated under the agreement because the breach was not a material breach. It may be argued that the untimely delivery of or failure to deliver earnest money is not a material breach of the agreement. However, if it clearly states otherwise in the contract, then the clear, unambiguous language will generally prevail. In this case, if the buyer fails to timely deliver earnest money in accordance with this paragraph, the contract now defines this failure as a material breach of the contract, providing the seller with a strong argument that he no longer has to perform under the agreement. Paragraph 4, property. Paragraph 4A and B, the paragraphs entitled Description of the Property and Type of Property, respectively, underwent no changes. There were some changes made to paragraph 4C, rights appurtenant to the property. The parties are no longer describing the mineral rights or water rights that are appurtenant to the property, nor do they have to disclose whether they will be conveyed with the property. Instead, the language now states that all appurtenant rights will convey with the property unless otherwise provided in the agreement. The buyer is then advised to seek expert and legal advice and assistance in determining the extent of those rights and in ensuring that those rights are properly transferred at closing. Paragraph 4D, that deals with fixtures and personal property, has been completely reformatted using bullet points. This does take up additional space, but it's easier to read and assimilate than a lengthy list wherein all these items run together. Additionally, the property that was listed has now been divided into two categories, fixtures and personal property. The items have been listed in alphabetical order. Paragraph 4D1 states that the property will include all fixtures unless excluded in 4E. The term fixture is now defined in paragraph 27 entitled Definitions. A fixture is defined as an article which once was personal property, but which has become part of the real property because the article has been fastened or affixed to the real property. It is important for brokers to familiarize themselves with the list of fixtures that will automatically convey with the property. However, if an article is not listed but falls within the definition of fixture, then it will remain with the property even if it's not on the list. This list is not all-inclusive. The following items were added to the list of fixtures: attached outdoor lighting and fountains, attached pot racks, built-in speakers and woofers, central vacuum to include hose and attachments, and pellet wood burning or gas stove. Also note that if the seller wishes to retain any fixture, whether it's listed or not here, the seller must include the fixture in paragraph 4E. Paragraph 4D1 covers personal property, articles that are not attached to the real property. The section will have checkboxes. Some items that were added to this section include freezers, storage sheds, unattached fireplace grates and screens, unattached outdoor fountains and equipment, unattached outdoor lighting, and hot tubs. There is space to include any personal property that will convey with the real property. Paragraph 4E, the exclusion paragraph, remains the same. Paragraph 5 is entitled Financed or Cash Purchase. 5A deals with loans. 5A1 is unchanged. In 5A2, the language was not changed, but the formatting has. The elements of the pre-qualification letter have been broken out into separate paragraphs, again because such formatting makes it easier to read. There have been no changes to 5A3. 5A4 has one significant change. It can be found in the last two sentences of the subparagraph. In the previous purchase agreement, it says that if a seller does not notify buyer of seller's position within 3 days, seller is deemed to have approved of such change in lender requirement. The revised purchase agreement says if seller fails to notify buyer of seller's position within 3 days of receipt of buyer's notification, seller is deemed to have rejected such change in lender requirement. In this event, the agreement will terminate and the earnest money will be refunded to the buyer. This change requires the seller to affirmatively agree to the change in lender requirements, opposed to assuming the seller's approval if the seller fails to respond. Remember, this paragraph is speaking to changes in the loan program that the lender is requiring that will adversely affect the seller, such as changes that will affect the buyer's ability to get the loan or changes that will increase the seller's cost or delay closing. It was decided that the seller should not be held to these new terms if the seller has not affirmatively agreed to such terms. In addition, the contract provides in paragraph 8 that the closing date can only be altered through written agreement of the parties. So to say in this paragraph that the closing could be changed automatically if the seller failed to respond timely could create an ambiguity within the contract, because under this section in the previous contract, there'd be no written agreement between the parties to change the closing date. It is very important for brokers to be aware that this contract will terminate automatically if the seller does not timely approve in writing of the new lender requirements. Paragraph 5B addresses seller financing. This paragraph still makes reference to the real estate contract addendum, RANM Form 2402, but now also makes reference to the new seller financing addendum for mortgages and deeds of trust, RANM Form 2507. This is a new RANM form which is to be used when the seller is providing seller financing, but the instrument being used is a note and mortgage or a note in deed of trust. The sections referring to Truth in Lending Act and the buyer's financial qualifications and the financial review period have all been moved to the seller financing addenda. Please note that RANM has not created, nor do we have any plans to create, a note or a mortgage or a deed of trust, and that brokers are prohibited by law from creating such documents. It's highly advised that the parties seek the advice and services of an attorney to prepare these documents. Brokers should be advising their customer and clients to do so. Paragraph 5C addresses cash purchases, and there have been no changes to this section. That concludes our presentation on this section of the revised purchase agreement. If you have questions on this section, please feel free to call me on the legal hotline. The number is 1-800-699-7266, or email me at legalhotline@nmrealtor.com. Thank you.